Catherine Seal is a senior member in the law firm of Kirtland and Seal in Colorado Springs. She flew in for this program. Catherine is the public administrator for the 4th Judicial District of Colorado, serving El Paso and Teller counties. She's the first person ever awarded an LLM degree in elder law from Stetson University College of Law, graduating with honors. She received her BBA degree with honors from Colorado State University and an MS degree in marketing from the University of Colorado in Denver. She received her law degree from the University of Colorado Law School. Apparently she likes going to school in Colorado. I don't understand that as a Georgia native. And holds a graduate certificate in gerontology from the University of Colorado. She's a member of the American Bar Association's Real Property, Trusts, and Elder Law section, where she serves as co-chair of the Surrogate Decision-Making Committee. She is president-elect of the National Academy of Elder Law Attorneys. She is the past chair of the Guardianship section. She is the past president of the Colorado chapter of CELA, and is one of only 7 attorneys in Colorado designated as a certified elder law attorney by the National Elder Law Foundation. As a member of the Colorado Bar Association, Catherine is past chair of the Elder Law section. She is the author of Colorado Elder Law, which is a Thomas West publication. Her practice is concentrated in the areas of elder law, protective proceedings, probate, financial exploitation of the elderly, and related matters, and she is my friend.
Wow.
I'm going to give my really short introduction and then let Catherine give her really short introduction, and then we're going to get the show on the road. We wanted to show you some of the things that you should do and some of the things that you shouldn't do, and we got together, was it back in April? I think it was around April.
Yeah, it was April last year.
And filmed here in Whitfield County in Judge Blevin's courtroom. And we used some witnesses, which you will recognize Mike, Catherine's husband, as one of the most unruly witnesses in this. And Melinda, who's been running around here, was one of our other witnesses. Some of them we threw to the lions. We gave them very little preparation, and we did that kind of on purpose so that you could kind of see what would happen if you don't prepare your witnesses properly. Robert McCurry was gracious enough to serve as our judge. You're going to see him ruling on our objections, and and
like a real judge would.
but the point is we're using this as a teaching tool. So you're going to see some things that, you know, hopefully some of it looks good, but some of it's going to look really bad, and hopefully we would never do that in a real case. Preliminary comment?
Little background. When we filmed this, we did not for a moment think about the fact that we would be later viewing ourselves on the screen in front of people, making some really horrific errors in the process. And it's a good thing we didn't, because we would never have had the courage to do it. The first time we did the video replay with an audience, I cringed. But the important thing is, despite the lack of preparation, what is really important is the fact that we're going to show you some things that went well and some things that really didn't go well. And it's important for elder law attorneys in particular are oftentimes really bad litigators. They go into elder law because they want to do things that keep them out of the courtroom. But in contested guardianship cases in particular, it's important to have people with an elder law background doing this litigation. And so in an attempt to help elder law attorneys build their litigation skills, not be afraid of the courtroom, and be willing to go in and try these tough cases, we've done this program in order to help people build on their litigation skills. So I'll let my own personal emotions about watching myself do stupid things on camera get out of it, and we'll critically discuss the things that we did and whether they were good or whether they were bad and what we would do differently now.
You can go ahead and start it, and there's a little preliminary text that we'll be playing. While that's going, I'm going to tell you this was based on a real case, and as I was doing the research for the paper that you have in the materials, I read several hundred cases and came across this little 3-page case, actually 2.5-page case, in Arkansas that caught my eye. And I called the attorney that handled the real case, and I talked with him and got him to mail me a lot of the original documents, including the depositions, and that was what we used as our basis for putting this together. The name of the case was Johnson v. Mitchell, and the parties, the putative ward was Lola Calhoun, 91 years old, and your client was Diane Johnson, and my client was, that was the daughter, and my client was Rebecca Mitchell, the granddaughter.
I was on the side of the angels.
Of course.
Counsel, call your next witness, please.
Your Honor, the petitioner calls, the petitioner, Diane Calhoun Johnson. Could you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your name?
Diane Calhoun Johnson.
Diane, how are you related to Lola Calhoun?
She's my mother.
You've been in the courtroom all day,
Yes, ma'am.
and you've heard all of the testimony.
Yes.
Can you tell me about the relationship you have with your mother?
She's my mother. I love her. With that being said, of course, we have the same mother-daughter relationship that a lot of people do. We have our moments of disagreement, but with that being said, we respect each other and love each other very much.
In fact, you moved to Florida,
Yes, I did, to be closer to my mom.
and your siblings did the same thing?
Yes, we're a very close family, so we wanted to be close to our mom, especially during her later years in life.
Did you spend time together regularly?
We spent time together every week. We would have a family dinner. We would do Bible studies together, normally on a weekly basis as well.
When your father was diagnosed with cancer, what happened to that relationship?
It was devastating. My dad, John, was the one that always made most of the decisions. So when John started getting sick, my mom was at a loss of what to do, and she just went into crisis mode.
Okay. Now, as you're preparing, Diane, and you know that this case is your client following her mother and a granddaughter from a different child from Florida to Georgia, and you're trying to say that your client is the better choice for conservator and guardian. What are you trying to accomplish here?
Well, as the facts say, this is the second case. And the first case was an earlier case that was tried in Florida. And the guardianship case was dismissed. It was found that there weren't grounds for guardianship. There were a lot of allegations that my client didn't have a close relationship with her mother. And the granddaughter, who was the one that was the current care provider and the one who basically had custody of Lola Calhoun, was going to talk a lot about how she was the one that was there and she was the one that was providing the care. So what I was trying to set up was the fact that my client really did have a relationship with her mother, and that my client, they had the loving, supportive family. So I was building that foundation to counteract what was going to be coming later, which was, no, you're not close. You didn't make any attempt to go find your mother. When the granddaughter took her from Florida to Georgia, she's been in Georgia, and you haven't really inquired about her. So I was setting up the, no, they're close, yes, they care about each other. Now, they had somewhat of a contentious relationship, so we needed to acknowledge the fact that the relationship wasn't perfect. And so we tried to deal with that by describing it as the typical family relationship that has its moments. So that's what I was setting up there.
You're framing the issues, trying to build credibility, and you're going to see some of this later. But one of my arguments is that Catherine, as a good advocate, is understating the contentious nature of the relationship significantly, because you'll hear me later accusing her client of dragging Ms. Calhoun back to Florida for this other litigation that ended in Ms. Calhoun's favor. One of the things.
Well, ended in an error.
Yeah. Now, we can agree to disagree on that. One of the things I thought was interesting as Catherine is questioning her witness, trying to build rapport, trying to build the closeness of the relationship, she refers to Ms. Calhoun's husband as her father. She wasn't. If you read the case, you find out that Ms. Calhoun's so-called father was actually Diane's stepfather. And so I think Diane was trying to presume a closeness that wasn't necessarily there. But a good advocate's probably going to do that. And if questioned on that, what are you going to say?
He's like a father to me.
Exactly. So, but I think you're during this session, this getting to know you part of the evidence, you want to show that your client is the best choice for guardian and best choice of conservator, and so you've got to establish that there's some basis for it.
Nope.
Let's go to the next chapter.
Why did you bring this proceeding today?
Because I love my mom, and I want what's best for her, and I want to know she's taken care of and protected, especially during the last years of her life.
Why are you here?
I mean, that's the most important question to ask.
And I'm not a judge. I don't get to wear a black robe, but I've got to assume that every judge wants to appoint a person who actually likes this ward and wants to take care of them. And so if you don't want to take care of your mom, then why are you here? And so I think that's critical. I think the other reason why that's important and why I think that was key that you did that at the beginning of the case is because money's going to become an issue very quickly in this case, and you want to diffuse that.
Right, because we are very careful, as I typically am in a case like this. We don't want to talk about the money other than in terms of protection, and we want to downplay the money, because if the court has to make a decision, and the decision is between the person in the family that's concerned about the finances and the person in the family that's concerned about the individual, the court's always going to go for the person that seems concerned about the individual. We were very concerned about the money. The money was gone. The money had been gifted. And we were going to have to deal with that. But I certainly wanted to lay the foundation that this was about the relationship between mother and daughter, the daughter stepping up to care for mother, and the daughter wanted to be there to make those important decisions and to keep her mother safe. But I wanted to lay that foundation before we ever got into the money, because the court doesn't like who's going to get the money. It's the pre-death will contest. The court does not like to see that in a conservatorship action.
And the whole point is to take, what's in the best interest of the ward, not who gets, who should have the ward's checkbook or who gets to spend the ward's money. If you're not showing that you're there to take care of Ms. Calhoun, then why are you there? Let's go on to the next one.
Cross-examination, counsel.
Yes, Your Honor. Ms. Johnson, you testified that you respect your mother.
Absolutely.
And as you were growing up, respect was listening to your mother and being obedient to your mother.
Yes.
And as you aged, respect was acknowledging that your mother's decisions matter.
Yes.
Now, your mother made a decision to execute a power of attorney and advance directive naming Ms. Mitchell as her agent. Do you respect your mother's decision there?
I would question if that was her decision or if she was coerced into signing that.
Do you have any evidence at all that Ms. Mitchell was behind that document being executed?
No, but I don't have any evidence that she wasn't as well.
And so you don't respect your mother's decision there?
Again, Mr. McGuffey, I respect my mother's decisions when I know they're my mother's decisions.
Okay. Did you respect your mother when you had a sheriff's deputy essentially drag her from Ms. Mitchell's home?
Objection to the
Florida?
characterization.
Counsel, don't be argumentative. Sustained.
Was it respecting your mother's decision when you forced your mother to return to Florida?
Mr. McGuffey, I love my mother, so yes, it was because I was very concerned about the care she was receiving and just her state of mind.
Did you respect the court's decision in Florida when the court decided that your mother was capable of making her own decisions?
I believe everyone can make a wrong decision.
So you didn't respect that decision?
She's my mother, Mr. McGuffey. I would do anything for her.
Now, did you respect your mother's decision after that court proceeding when your mother went back to Georgia?
Again, I do not trust that it was my mother's decision to go back to Georgia.
Now, you don't have the benefit of the full, 6 hours that we spent video or taping this. We took out what we thought were the best spots for educational purposes, but Melinda was a hard witness to get at, and so I was trying to rattle her here. I was trying to get at the fact that Ms. Calhoun has made some prior decisions. She's expressed her opinions. She has said what she wants, which is her granddaughter will be the decision maker, and so I'm trying to see if she will cross over with me and agree to any of that. Of course, she didn't. But one of the things I was concerned about as I was doing it and as I was watching it in hindsight is this is not a jury proceeding. This is a non-jury proceeding. And I know I've got at least one retired judge here. I mean, how well does that kind of theatrical stuff work when you don't have a jury? It's the judge. Yeah, it doesn't do much for the judge. So unless you're going to, unless you're really accomplishing something with the witness, you got to be mindful that the judge may be sitting there shaking his head and wondering, why are we going through all this? So that's one of the things that I was considering in hindsight as I was thinking about this. You can't always be looking for one of these Perry Mason moments where you feel so good about yourself because you got them to confess on the witness stand. And unless you really get that confession on the witness stand, it may just be a botched show.
I actually thought he did me a great deal of damage here. And the thing that the minute I saw her roll her eyes at the first question, I thought if I had any idea that she might roll her eyes, I would have told her not to do that. Because you don't know if the judge saw that, but it's certainly going to hurt your credibility if your witness does that when they're questioned. Now, I know there was a personal dynamic here. She was being cross-examined by her boss, and so I think that was part of the reason we got a little more sassiness, a little more pushback than you normally would. But I was happy that she was firm. I would have preferred that her words be slightly different in terms of the court got it wrong. We were dealing with a court that had ruled in Florida, I think about 18 months before that, that the board, the way that Florida does that with the 3 people who did the examination, they weren't in agreement that she lacked capacity. And so obviously you've got someone who's declined since then, so you can certainly argue that things are different, but we had made a decision to not go on record as saying that Florida was right. But you have to do that in a tactful way because you're in a courtroom, and if you're telling a judge that the last court procedure was incorrect, you have to kind of soft pedal it. I thought she did a fairly good job, but would have preferred the verbiage be slightly different. But I thought she did a good job of standing her ground and not letting the cross-examination push her into agreeing with anything that would have hurt her case.
Now, if you can prepare your witness right to withstand some of that, then that's great. The only way I think I'm going to win, the way I think I'm going to win that kind of theatrical show is I either have a jury in the box and somehow or another they find that entertaining, or I managed to break her down. And I don't feel like I broke her down. I don't know how y'all felt watching that. I think that's a great point, and we hadn't made it so far. Know your judge. You are trying to persuade someone. You are trying to present enough evidence to show that your client should prevail in a contested proceeding, and the judge is going to be the decision maker, so you need to know your audience, know your judge as much as you can.
Can get away with. But I used to do a lot of criminal defense work. And I can tell you in 22 years of practice, I've had one Perry Mason moment where I actually got somebody to admit that they were lying on the stand. It just doesn't happen very often. And so that methodical building block approach to building your point, at least in my experience, has been what really works, and not the, every once in a while you've got somebody on the stand and you want to pull away the facade that they're this calm, logical person and show what a nut job they really are. And maybe then you can poke at them until they show their other side. But, those Perry Mason moments just don't happen very often.
Play the next one.
Let's proceed, counsel.
Thank you, Your Honor. Would you raise your right hand? You swear the testimony you should give should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you state your name for the record?
Rebecca Mitchell.
You are a petitioner in this case, and you've asked to be appointed the guardian of your grandmother. What was your involvement, or how did your grandmother come to live with you, if you can tell the court just how that occurred?
She wanted to come back to live with me.
So your grandmother came back to live with you. Was there a point in time when she went back to Florida?
Yes.
How did that happen?
The cops had come to the door and took her
The cops came to the door and took her. Why did they do that?
for another conservatorship that was filed down in Florida.
Okay, so they took her. Did she want to go to Florida?
No, she didn't.
And the outcome of that case, we know from the record in this case, was that it was dismissed. What did your grandmother do after it was dismissed?
She came back to live with me.
One of the first criticisms I would have of myself, what do most of your really innovative winning football coaches do when they are starting a game? They script out the first 10, 15 plays. Did you see any notes in my hand? And, it looked like I'm fumbling a little bit. If you're going to court, sure, you don't want to read your case. You want to know your case. But you should also probably have those initial notes in your hand so you don't look like you're fumbling the ball, doing this. And that would be one of my initial things. I'm trying to frame issues. I'm trying to frame a relationship. I'm also trying to have my witness show, again, because we think this demonstrates that your client is a bad actor. She had her mother drug to Florida involuntarily by the police.
No, concern for her safety, she took the appropriate measures. And my question is, where the heck was I? Was I asleep? She wanted to go to Florida. Why am I not objecting? Why am I not objecting to that characterization? Why am I electing to? That's less worse than hearsay. We have no foundation for she wanted to go.
Well, I'm also
She's not even present.
I'm also
Nobody's
asking, what does she
established that.
think?
Yeah, what does she think?
How does my client know what she thinks? There's no way unless my client's a mind reader, she doesn't know what she thinks.
So,
If you can get away with the hearsay or what she thinks, that's fine. It was her job to object to it.
right.
I'm concerned.
I was completely asleep at the wheel.
My client. I have a big mouth. My clients never have trouble hearing me. Miles is mild, but mine, they're like, you don't have to yell. With David, and maybe because we didn't see the whole thing, but I kind of wanted to hear, it was confusing. I wanted to hear her story. Why was grandmother living with her in the first place? What's the backstory behind that to why should she get grandma and not the daughter? Because technically the daughter would be first in line as far as the law goes, right? So we didn't see that, and maybe we just didn't see that part of it. I don't know, but I would have started with questions like, tell me about your grandmother's your relationship with your grandmother.
And that is a long and convoluted story. I will tell you that my whole viewpoint on the Florida thing was I wanted to get over with as quickly as possible because this was the bad part of the story for my client, which was she had tried a proceeding in Florida. She had filed one and had mom taken out of state. The way the granddaughter ended up with custody of her grandmother in the first place is that the granddaughter took her grandparents out of state when the grandfather was ill. And you'll hear more about that later. Isn't that part of the video? Do you have a video clip on that?
It is.
Yeah.
Actually, you're about to cross-examine.
And that's the best part of the story for me. So.
But to kind of give you the nutshell version, some of it you probably missed because I talked through the Star Wars text that you saw scrolling up. I thought that was really cool. I don't know if you did too. But the backstory is that Lola Calhoun and her husband, who is the stepfather of your client, they lived in Florida, and Mr. Calhoun was diagnosed with cancer, so Becky Mitchell, the granddaughter, comes down to Florida to help out. And
She wasn't asked. She just showed up.
we can agree to disagree on that. When she gets down there, as you read the case, you find out that a couple of years before, and presumably not at Becky Mitchell's behest, a couple of years before, the Calhouns had executed a power of attorney and a healthcare advance directive naming Becky as their agent. So when she gets there to help out, at some point Mr. Calhoun recovers enough so that somebody, I don't know if it was him or Becky or Ms. Calhoun, but someone decides to move them out of state. And 5 days after, in the real case, they went to Arkansas. We changed it to Georgia. 5 days after they get to Georgia, Mr. Calhoun dies. And you're going to see Catherine really take my client to task over that in the next segment. But that's kind of the background here.
And how much longer was Mrs. Calhoun in Georgia before the daughter sent the cops to get her?
I think they were in Georgia 6 months or so.
It wasn't like right after.
Mr. Calhoun died. Mm-hmm. They get dragged back to Florida for a proceeding. Well, that's my story, and I'm sticking to it. And the Florida court decides to dismiss the proceeding because there's not enough evidence to show the need for a guardianship or conservatorship.
Because the examining committee can't decide.
When you come back to Georgia, is that not damning to your case that she needs a conservator? Seems pretty damning to me.
Well, the Arkansas court, when they're discussing it, they discuss it in terms, and I don't think I'm mischaracterizing this, they discuss it in terms of because the court dismissed the conservatorship action in Florida, Ms. Calhoun retained the presumption of capacity. And there was no clear evidence, although your expert tried to get there was no clear evidence that a couple of years prior when she executed the power of attorney and healthcare advance directive that she lacked capacity at that time.
But we had a series of events that were going on. While they were living in the actual case in Arkansas, they ended up with the house being blown down in a tornado. Was that what happened?
I think in the real case it was a tornado.
Okay.
Or no, it was a flood.
It was a flood.
It was a
Okay.
flood. We changed it to a tornado.
Okay. And so they ended up in some sort of shabby substitute housing for a while. Nobody could locate them, so nobody from Florida, they had trouble finding them at first. So there was a lot of concern. And then by the time this case has started, Lola doesn't really have any money anymore. And the reason Lola doesn't really have any money anymore is because Lola's gifted all of her money. And one of the things Lola's done is to help poor granddaughter Becky get back on her feet. Most of her money goes into a house for Becky and a car for Becky. And of course, then there's the local pastor, and he gets some too. So Lola's transferred all of her money away. So we have the, dear granddaughter who cares so much, who drags the dying grandfather to Florida, and he nearly dies on the road. And then you have grandmother, the survivor, impoverished of the wealth that she and her husband had accumulated to the benefit of Becky. So there were definitely some bad facts on the granddaughter's side as well. So it's
Does
your
that-
typical case. There's
that-
bad stuff to go around.
Paint a little more of a background story.
Oh, yeah. Yeah.
And just so I'm clear, is this a guardianship or conservatorship, both, or?
It's both. In Arkansas, they were seeking. Actually, I think they were seeking permission to take Ms. Calhoun back to Florida.
Back to Florida.
And and your client was seeking power not only over whatever money was remaining, but the right to sue Becky to recoup what had been gifted.
Oh, okay. So there's an action for that, but what we're doing here is really just the guardianship. Is that correct?
Right.
We structured this. We tried to change the facts to Georgia because I'm not an Arkansas lawyer and I don't claim to know anything about their law. We
Right.
just kind of like the fact pattern.
But the way that the fact pattern is being presented now, just for my edification, because I'm not really clear about the distinction.
Guardianship and conservatorship.
So
Okay, but the money's not an issue anymore.
we're going to
in
be
this-
looking at the money, and you'll see some questions on the money as well.
Okay, good. Thank you.
Yeah.
Presume that if Catherine wins, she's going to try to reverse the gifts. She's going to try to go after them. Let's do the next chapter. Well, I guess, now, when you got to Florida, did you discover that your grandmother had basically asked you to be her helper?
Yes.
I'm going to show you what's been marked as Petitioner's Exhibit 1 and ask you if you recognize that.
Yes, I do.
What is that document?
It is a power of attorney that my grandmother had gave me.
Your Honor, we will move for the admission of Exhibits 1 and 2 in this case.
Any objection?
Yes, Your Honor. The witness does not appear to have any knowledge of the circumstances under which these documents were executed. Should not testify to any knowledge of the execution of these documents.
Any other basis?
We have no knowledge of whether or not these documents were coerced. We have no knowledge of whether or not she had capacity at the time these documents were executed.
I believe that would go to the weight of it. From what I understand, the testimony is that these documents were given to her when she went to Florida. I'm going to ask the one foundation question. Can you recognize your grandmother's signature?
Yes.
Do these documents appear to contain your grandmother's signature?
Yes, to the best of my knowledge.
Well, to the best of your knowledge, do you recognize your grandmother's signature, yes or no?
Yes.
And do these documents contain your grandmother's signature, yes or no?
Yes.
Objection denied, documents admitted.
Now, when you were given these documents, did that, together with your grandmother's comments, cause you to believe she wanted your help?
Yes.
Did you participate in the preparation of these documents?
No.
Were you present when someone else prepared these documents?
No.
Okay, has anyone ever heard of the word grace? There's a lot of grace going on here because I totally flubbed the introduction of these documents. And yet this judge helped me out. If I had remembered my law school and remembered what I believe it was Professor Millich, I'm pretty sure it was him because he taught evidence, although it could be Professor Lanier. They showed me a book called M. Winkleread's Evidentiary Foundations, and it's not just a law school book. If you're not sure how to introduce something, I would go back and look at that and take that with you to court, because if you flub like this, you may not get a judge quite as nice as Judge McCurry. And he basically got that evidence in for me because
It was totally wrong objection. That power of attorney was coming in, though, no matter what.
Yeah, it was-
And, there was nothing I could do to stop it. I just wanted to rattle him a little at that point. So,
well, I was listening to my judge, but I also agree with what Cam Newton recently said. Show me a good loser and I'll show you a loser. I was going to keep trying to get this in, and I would have had a much better job if my judge wasn't gracious, if I had actually been prepared and if I had actually had my evidentiary foundation notes in my hands.
but it really doesn't matter because you're in a guardianship proceeding. The power of attorney executed by the respondent is coming in. That's just a fact. I've never seen it not come in.
Well, it's relevant to show what was the putative ward's choice as to guardian and conservator or decision maker.
But I give you a few seconds of a really bad time.
Well, I had to, pop another antacid there. But then I also wanted to put up evidence to show that Ms. Mitchell was not present at the time those documents were created. Obviously, that's one of the red flags when people are looking to see if there was coercion, was the supposed wrongdoer present and, in the room when the documents were done. And we wanted to put up evidence that she wasn't there.
And we've all seen that. We've seen the documents downloaded off the internet and signed by the principal in the presence of the agent, who's the one who did the download. I've even seen it where the agent actually filled in everything and then the principal just signed. We've seen it where the agent makes the appointment with the attorney and is present, and it's the attorney who doesn't know any better and lets everybody be in the room when they execute the documents. But even with a power of attorney that was executed where the agent wasn't present and where you can't show that they participated in the execution, there are a lot of other reasons to ask the court not to appoint the agent, even in states which have a presumption or where the document contains a presumption that the guardian or conservator who's appointed be the agent under medical or financial power of attorney. You can still, there are a lot of other reasons, conduct of the individual, appropriateness of that individual to serve. So it's never determinative that the document appoints that individual individual is going to end up serving.
Now, we'll get your question in just a second. Assuming that Catherine and I have a professional working relationship and we actually talk to each other, what's another way I could have, would have been a lot easier to get those documents in? Stipulate.
And we should have. We should have stipulated a whole bunch of the documents at the beginning because this thing took a lot longer because we were arguing with each other's evidence. So.
Have you ever used a forensic psychologist to contest the competency of the principal to execute the power of attorney, as in this case?
I do it all the time in will contests. When and I've got one right now that's a trust case, and the question is the capacity of the individual to execute the trust amendment. So do it on a regular basis. It's harder to do when the individual's dead. And we're looking at prior medical records. But it's just as difficult for an individual who now has dementia. And then the question is this individual even going to bother to interview the principal? Because they may not get anything useful out of the principal at this point. What you're really asking is 5 years ago on this given day, given the prior medical records and any other evidence you can gain by interviewing people who knew that individual at that time, can you get the opinion that they did not have the ability to understand the documents at the time they executed them? Yeah, that's always an important possibility. In this case, those documents were 5 years old. There wasn't anything in the records of this case that indicated that Lola Calhoun didn't know what she was doing 5 years ago. So that would have been, I think, really difficult. I think I may have tried.
Didn't keep you from reaching there with your expert?
I tried the best I could, but I had very little evidence. But my husband gets drafted as my expert witness at lunchtime. We tried this thing right after lunch. So he has to become a psychologist in the space of about half an hour. And he did a fairly good job with no professional education in psychology.
Let's do the next one. This is the unprepared witness.
Ms. Mitchell, you took your grandfather to Georgia when he was dying of cancer, didn't you?
Yes, ma'am.
In fact, he died 5 days after you arrived.
Yes.
Don't you think the travel had a significant negative impact on his life?
Possibly, yes.
Wasn't that an exercise of poor judgment?
Yes, looking back, I do believe so.
You heard the testimony of Dr. Kirtland
Yes, ma'am.
and the results of the tests.
Yes, ma'am.
You think you know more than the doctor about this subject?
No, ma'am.
But you're disagreeing with the doctor.
Your Honor, I'm going to object. We've had more than one doctor testify, and they didn't agree with each other. So I think this is argumentative.
I find it argumentative, counsel.
Oh, well.
I mean, she can testify as to her opinions, but asking her to comment on someone else's testimony and whether she's more intelligent than another witness or not, I think that's argumentative. Sustain the objection.
If your grandmother is found to have dementia and all the money she's given you is ordered returned to her, won't that place a severe financial burden on you?
Yes, it would.
You don't get along with your Aunt Diane, do you?
No.
And in fact, you've refused to allow her in your home, haven't you?
I've never stopped her from coming to my house to see my grandmother.
You've never told her she wasn't welcome in your home?
No, ma'am.
So nobody's going to testify today that you've ever said that?
No, ma'am.
You've not kept Diane and her sister and brother informed about their mother's condition, have you?
No, ma'am. I believe that was on my grandmother.
You were here when Mr. Winter testified. Do you know what the effects of these gifts will be on your grandmother's eligibility for Medicaid?
Yes.
So she will not receive Medicaid if she needed the care.
Right.
And you would have to give back the money in order for her to qualify.
Yes.
Did you know that at the time you took the money?
No, ma'am.
Did you obtain any information regarding this?
No, ma'am.
You didn't seek out any legal advice?
No, ma'am.
Now, you were serving as an agent under power of attorney?
Yes.
You've just given us the documents that have been admitted into court regarding the fact that you accepted appointment? Mm-hmm. When you learned that you were a power of attorney, did you obtain any legal advice regarding your responsibility as an agent under power of attorney?
No, ma'am.
So you don't know under what rules you're operating?
I do somewhat, but not.
You testify that your grandmother cares for your children?
Sometimes, yes.
Now, we heard testimony that she goes to daycare. Why is it that she goes to daycare?
I want her to have socialization with others besides my children and myself.
Isn't it true that the reason she goes to daycare is because she's not safe at home alone?
I trust her at home.
You would leave her at home for extended periods of time?
It depends on the situation.
Well, I think we've heard testimony that she can't stand for more than 10 minutes or so at a time. And you would leave your grandmother at home for extended periods of time?
At night when she was sleeping, maybe. But
what would happen if there were a fire?
I've never thought about that.
You've not thought about what you would do in it? You've been through an emergency situation. You've been through a tornado.
Yes, ma'am.
And you've not thought about emergency planning for an elderly person living in your house?
No, ma'am.
You don't have an emergency plan?
No, ma'am.
No evacuation plan? No emergency kit with medications and doctors' phone numbers and all those sorts of things? You're in a tornado-prone area? You've not made any of this sort of planning?
I do keep her medication and her doctor's information in one spot.
In one spot, but you don't have a backpack. You're not ready in any case of emergency.
Now, in Amanda's defense, she had probably 15 minutes of preparation for this, maybe a little more, but not much. And you shredded her.
Oh, I did my best.
You know, one of the things that came to my mind as I was listening to Vicki Kind yesterday, one of the things that she said is, your mother's okay at home sometimes? What time is she okay? And what are those times when she's not okay? And she's okay sometimes. Which days would she be okay? And that's kind of what we had going on here with this witness. At least that's how it appeared to me.
I really wanted to show that, I mean, you don't want to stay and dwell on the money. So I wanted to make the point on the money and then move back to the fact that she's not the awesome caregiver that she's trying to lead everybody to believe she is. The fact of the matter is she's got grandma in her custody, and if she can't provide for grandma, grandma isn't going to qualify for Medicaid because of these disqualifying transfers. So she's got a problem. So,
but let me stop you there. Where am I? I mean, I'm kind of missing in action because you asked her for a legal conclusion.
right.
Objection? and you got away with that.
Yes, I
'Cause
did.
I was kind of missing in action.
Because we both managed to score points when the other side was not paying attention. But the big point here is, if you dwell on the money and stay too long on the money, again, the court says, it's all about the money. So if it's a choice between two fiduciaries and you have a money issue on the other side, you have to move to the money and back from the money, to the money and then back from the money. You have to move back to the care issues, because if it's all about the money, the court says, these awful kids, they're just fighting about the money. Nobody really cares about mom. So I had to go back to the care issues again and show that what we were really concerned about is mom's not really safe at home. You've got somebody who can't stand for more than 10 minutes, and you're leaving them in charge of your children? That's insane. So
The other thing that I thought was beautiful, and she got away with it because, again, I'm missing in action, and this is where you really have to pay attention if you are in one of these cases so that you can protect your witness. You asked questions, what training did you have on the use of the power of attorney? There's no evidence in the original case that she ever used the power of attorney. We know there is one. We know that there were gifts made, but there's nothing in the case that tells us that the gifts were actually made using the power of attorney, and yet you're taking my client to task because she didn't go get training on how to use a power of attorney. And you got away with that.
yes, I did.
Because I'm not defending my witness. You've got to pay attention to what's going on here.
And a lot of times that's what the perpetrator does. If they're smart, they know not to use the power of attorney. They know to have the principal sign the checks, because then they don't have to worry about the fact that there's going to be a claim that the power of attorney didn't have a gifting authorization or couldn't make gifts to the agent or whatever. So the smart perpetrator always has the principal sign the checks themselves.
And if you're preparing a witness who's just gone through a tornado, you got to think that they've at least been prepared, or you've spoken with them about whether there's an emergency plan. I mean, that just made her look stupid.
No, it made her look dangerous. It made
Yeah.
her look like a really poorly qualified caregiver.
Negligent, yeah.
Yeah. So.
Anyone else have any other thoughts on that? Because I thought that Catherine just shredded this witness.
That's okay, because your doctor killed me, if I remember correctly.
Let's do the next one.
Petitioner, call your first witness.
Thank you, Your Honor. Petitioner calls Dr. Robert Simmons to the stand. Dr. Simmons, would you raise your right hand? You swear that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And we are taping for the record, and so I'd ask you to state your full name.
My full name is Dr. Robert Simmons.
And what is your experience in the medical profession?
I was trained at the Medical College of Georgia and did an internship and residency in Macon, Georgia, went to the Air Force, came to Dalton, and have practiced geriatric medicine here for 42 years.
And have you had an opportunity to examine Ms. Lola Calhoun?
I have.
And when did you examine her?
February 9th, 2015.
And where was that examination done?
At Dalton Family Practice.
And who was present during that examination?
In the room itself, Ms. Calhoun and myself only. Mrs. Mitchell, her granddaughter, was present, but outside in a waiting area and was not in the room with us at the time.
What occurred? What did Ms. Calhoun say, or what did you do?
Well, initially, I introduced myself and asked if she knew why she was there.
And did she?
She stated that she was very pleasant, by the way, and stated that she was there because she had to be.
And what happened after that?
I began to talk to her about certain things in a little bit of a questioning way, but not quite a probing way, establish again a little more familiarity because she was a little uncomfortable in the setting. I asked her some questions about, well, in fact, I did a direct clinical review. At that point, I guess that's when I started my questioning.
What's the purpose of that review?
Well, the purpose of that review is to create a series of questions that help determine current level of function and possible capacity. It helps establish a baseline. It also gives us some idea if the circumstance is likely to improve or not.
And what did you find as you conducted your direct examination?
Well, first of all, I asked her questions about her medical condition, about what recommendations her doctor had made about her medications. And, you know, the questions sort of depend on the circumstance. They're really simply designed to see if the patient can process information accurately.
As you did this examination, did you arrive at any conclusions regarding her capacity?
I did.
And is that an opinion that you can give regarding her capacity?
Yes, there is an opinion I can give.
And is that an opinion?
Just to give you an example, she had good recall of some things, and she had not good recall of other things, and some things she was somewhat confused. For instance, at one point her son had died, and at another point her son was living in Georgia. She remembered about a husband's death. She remembered a husband's death triggered her move to Georgia with her granddaughter. She remembered her daughter. But she was confused about other things, and I thought fairly important things. So I did draw a conclusion that she was at reduced capacity to make decisions about all things about herself, but in particular about command functions such as finance.
Now, we've got a doctor that looks kind of like Marcus Welby, and I love that flag. You know, the doctors don't wear that. He had the flag on his coat. They don't wear that coat outside the hospital or outside the doctor's office, but Dr. Simmons is a real doctor. He's retired, and he asked, what should I wear? And I told him, you don't have to wear a suit, so that was how he dressed for court. We're trying to set up, on my side of the case, a limited guardianship, a limited conservatorship. We're trying to show that Ms. Calhoun can do some things but not others at this time, and that at the time she did those documents naming Ms. Mitchell as agent, that was her choice. And the next segment, I believe, is where I will ask him, could she make that choice? Could she choose who would be her decision maker, her guardian or conservator? But we're trying to build some credibility as we at least get to the point where, yes, we need a guardian and conservator, but it should be Ms. Mitchell serving in that capacity.
I now know that if I ever try a jury trial in front of a jury, a guardianship in front of a jury, which you can do in Colorado, but we don't often get a request for, I'm going to make sure in advance that the doctor doesn't show up wearing a freaking lab coat, because the credibility of Marcus Welby there in front of a jury would have been just devastating. So it's on my list now of things that if the case is tried in front of a jury, I'm going to file a motion in limine to make sure that the testifying expert doesn't show up, looking like that.
I diminished all the back and forth between what the granddaughter did and what the daughter did. I really looked to what Simmons' opinion about competency, and then, of course, the other physician's opinion about competency, and weighed the two professionals. And I felt it would be easier to go with the professional opinion based upon the anecdotal evidence of whether or not you got her on the tornado or the health care plan. I didn't really care because I was looking to what Simmons saying, whether she was competent or not.
The lab coat that killed me, wasn't it?
No, actually, it's knowing your judge and knowing your community as you're picking your judge. Dr. Simmons is, in this community, he's one of our leading geriatricians for the last how many years? Yeah, 30 years.
What about my esteemed witness? Wasn't he good?
I've been a doctor for 15 minutes. You gave a lot of mumbo jumbo tests.